Member for Hastings.
Thank you, Acting Speaker, and I'm very happy to rise to make my contribution to the Justice Legislation Amendment, Integrity, Defamation and Other Matters Bill of 2024. It's a very big bill with many facets and nuances, and I would like to thank the member for Malvern for his contribution. It was great to hear your inside voice for a change. I appreciate that, but I certainly did like the member for Ovens Valley, I feel like you've covered it pretty well and I might just sit down. But my community did give me a seat at the table and I will take the opportunity to continue. From memory, I've only been here for a year and a half, but this bill is so big that the second reading, which is normally about 2 pages, was 14 pages long. So there is a heck of a lot of information in this bill and I thank everyone who worked on it. Just so the people at home get an idea of the amount of changes in this Act, I will outline that this bill is for an Act to amend the Crime Statistics Act 2014, the Criminal Procedures Act 2009, the Defamation Act 2005, the Freedom of Information Act 1982, the Independent Broad-Based Anti-Corruption Commission Act 2011, the Judicial Commission of Victoria Act 2016, the Local Government Act 2020, the Ombudsman Act 1973, the Privacy and Data Protection Act 2014, the Public Interest Disclosure Act 2012, the Public Interest Monitor Act 2011, the Racing Act 1958, the Spent Convictions Act 2021, the Surveillance Devices Act of 1999, and the Telecommunications Act of 1988 and the Victorian Inspectorate Act 2011 and more. And I'm exhausted, but I'll keep going with a little more detail. This bill will make changes to the Crime Statistics Act of 2014 so that the Chief Statistician can access court data, amending the Criminal Procedure Act of 2009 so that electronically signed documents are admissible in criminal proceedings and will allow the continued use of digitally recorded statements. It also makes technical and procedural amendments to various Integrity and Justice Acts to improve how they operate, and it will also amend the Act that the opposition leader would be well aware of, the Defamation Act of 2005, so that nationally developed reforms can be enacted. Essentially, this bill is bringing our justice system up to speed in 2024 by allowing things we all do in everyday life, like electronically signing documents, and by extending the use of digitally recorded evidence so there are more options for our victim survivors so they aren't burdened any more than they need to be as they go through the justice system. We also know that a good number of people within our communities want to see our justice system perform the best it can, and this bill provides the chance for our justice system to improve. By allowing the Chief Statistician to access court data helps them understand how people interact with our justice system from the first time they talk with police up until the very final outcome in the courts. They use this data to make linkages with other data so they can develop better policies, identify what may be cause of concern in the future and bolster the delivery of justice services. Now, some might be listening to this and think, but doesn't this open it up to people accessing data that they shouldn't be seeing? Well, this bill ensures that only authorised people will be able to access court data and also make sure that unauthorised access or disclosure of data is an offence and can land a perpetrator up to 5 years in prison. The Chief Statistician will work within the framework of the Privacy and Data Protection Act of 2014, and this bill also provides protection to ensure that the Chief Statistician can only access data that's needed for statistical analysis. Just that measure alone of the use of digitally recorded evidence will help protect victim survivors, which are predominantly women as well. This government will always do what it can to protect the safety of women in our community. This bill also makes very pragmatic changes like the use of electronic signatures, bringing parts of our justice system into the year 2024, as electronic signatures are used by a variety of different organisations and systems these days. This reform will resolve any ambiguity, enable justice agencies to confidently use existing technology to capture signatures electronically, and increase agency efficiencies and reduce system delays. If you do still want to sign physically, that is an option that will remain available. It's just about making things more accessible and efficient. The bill also makes important changes to provisions in the Defamation Act of 2005, and one of these crucial changes is to extend the defence of absolute privilege to matters published to police. These are reforms led by Victoria and is aimed at addressing what the threat of defamation can have on sexual violence and harassment reporting. Amending Section 27 of the Defamation Act to extend the defence of absolute privilege to reports published to officials of Australian police forces or services acting in their official capacity, providing a complete immunity and defence to a defamation claim. This provides vitally crucial certainty to those who are reporting matters to police, knowing they will be protected against a defamation suit for that report. This just removes another barrier that people sometimes face when making the decision to go to the police or not. Victims should absolutely feel confident and comfortable making reports to police and not be scared under a cloud of a potentially long and costly defamation suite. When it comes to sexual harassment and violence, victims should absolutely feel like they are protected in sharing what has happened to them with police. For too long, we've seen mass amounts of underreporting based on many different factors, but one we all hear about way too often is that they're fearful to come forward. They're fearful to report because it may come back to the perpetrator, who could then use many avenues to inflict more pain, stress and anxiety. This could be done through a defamation suit, which not only is a long process but a massive financial burden to someone going through an awful time. This bill will bring down that barrier, and if it only helps one person have the confidence within themselves to report, then that's a win in my eyes. One of the other wins in my eyes is the ongoing use of digital recorded evidence in chief in family violence proceedings. So one of the responses to the recommendations in the Royal Commission into Family Violence was Recommendation 58, which encouraged and supported a trial of digitally recorded evidence, primarily from body-worn cameras on police officers. The first trial was started in 2018 and was subsequently extended through to June 23, but there was a sunset clause put in for the trial, and so that's now due to be repealed in October 24. Allowing the use of digitally recorded evidence in chief means that victim survivors of family violence, of a family violence incident, can continue to have a choice to either make a statement via police-issued body-worn camera or in writing. Now, the strength of this means it allows the victim survivor to provide their statement in their own words at the time of the incident, which can obviously be a far more powerful tool than a statement which was written down at a later date. It is also considered that providing a statement in this way may eliminate or minimise the need for a victim to relive their experiences when giving an interview at a later date. And additionally, there is some anecdotal evidence and reports that recorded evidence can lead to the accused entering a guilty plea earlier to proceedings, thanks to them being able to physically see the video evidence from the scene of an alleged domestic violence incident. And I think that's an absolutely fantastic thing. As mentioned previously, this bill is also making various technical and procedural amendments to a variety of integrity and justice acts to improve the operation and effectiveness of our integrity agencies, such as changing the name of the Victorian Inspectorate to Integrity Oversight Victoria and the Inspector as the Chief Integrity Inspector. These are very simple changes but are better understood now by the public on what their roles are, and I certainly agree with that. It provides greater protection of information about a person's sexual orientation under the Privacy and Data Protection Act of 2014, enables search warrants to be issued to allow an IBAC authorised officer or police officer to execute a search warrant, and delivers on procedural amendments to the Freedom of Information Act to support better administration processes. Speaker, to summarise on this debate, the passing of this bill will provide more avenues for victim survivors of sexual harassment and violence to report to police, allow greater access to court data for the chief statistician so they can find ways on improving our justice system from top to bottom, and also this bill makes some minor but needed amendments to a few justice and integrity acts so those agencies can run more effectively. I see this bill as improving justice and integrity and, crucially, providing protections for those dealing with the awful scourge that is sexual harassment and violence. I commend this bill to the House.